lot of focus lately has been on the Second Amendment, but obviously the First Amendment is also a majorly important civil liberty in this country. Not only do I exercise my First Amendment of being a member of the free press, but also free speech, free assembly. You've got free religion. No religion can be forced upon you. Then you've got the Second Amendment right behind that. Well-regulated militia being necessary for the security of a free state. The right of the people to keep and bear arms shall not be infringed. Well, while we track what happens with the litigation against Illinois' gun ban, what about other litigation against First Amendment issues? And one of those things brought up is the issue of the state's firearm liability law that allows for the Illinois Attorney General to sue for deceptive practices firearms industry members, and allows the private right of action to go against manufacturers or those associated with the firearms industry if they allegedly make the public less safe, if they have advertisements that are geared towards children, or if they have advertisements that are geared towards what the state may consider illegal militia activity. So clearly, there are some questions about the First Amendment in those cases, but there has been litigation against this, and it's been ongoing ever since the measure was signed over the summer. But you have the case in the appeals court, or not in the appeals court, but in the Southern District of Illinois, National Shooting Sports Foundation v. Raoul, and the case, of course, has been filed, and the plaintiffs have had their piece to say. You've also got the Attorney General in the state of Illinois that requested a delay in that case to reply. While they were granted that, and that deadline to file their reply was yesterday. So that was actually filed on Monday. So we've got the state's response here. And it's, it's a 7-page filing, and we'll just kind of go through this a bit. It says that the National Shooting Sports Foundation's response confirms this court does not have subject matter jurisdiction. So they're making a jurisdiction argument. They say that NSSF's declarations do not establish standings. The response ignores how the state explained the declarations do not cure Article 3 defects, and no declarant identifies a single dollar an NSSF member lost or will lose due to the law. So it goes on to spell out how they don't have standing. Even more, talking about they can't create a gotcha standing. So some interesting language in this filing. They also argue that the plaintiff's response confirms that it's failed a state to state a claim. So that's another response that the state's throwing out there. And again, these were responses that were allowed to be delayed. So that case is still proceeding. What happens next here? We'll keep an eye on it, because there's various different arguments that you can make about that particular case. But that's not the only First Amendment case that's been moving forward. You had another case, doesn't deal with firearms. It deals with the issue of reproduction, of whether or not somebody who finds themselves to be pregnant, woman goes to a clinic, and that clinic is a pregnancy crisis center that talks about the options that are available, like adoption, or giving them resources to take care of the fetus as it grows, and being able to give them the proper resources. Pregnancy crisis centers. One thing they may not do is talk about, hey, you can go abort that fetus. You can go and have an abortion and terminate that pregnancy. So there are some facilities that don't steer women towards an abortion. Well, the state of Illinois, over the spring session, they passed a law that would allow for the state to go after these pregnancy crisis centers and charge them with deceptive practices. And you had Illinois Attorney General Kwame Raoul even share an anecdote about how he attempted to, test this, and was told by one clinic to, avoid, abortions or something to that effect. I'd have to go and look at the archives for exactly what the Attorney General had to say. But regardless, that measure passed, and then it allowed for crisis pregnancy centers that don't offer abortion to be sued by the state. Some people saw that as a violation of their rights. And the National Institute of Family and Life Advocates, they filed a lawsuit, and that lawsuit has now come to a point here where you've got apparently an agreement. So the parties have negotiated an agreed order to resolve this action and jointly move the court to enter it. Pursuant to the court's procedures, a word version of the agreed order will be submitted. So what's interesting about this is the judge had already said, issued a preliminary injunction, by the way, when the National Institute of Family and Life Advocates, when they filed their suit shortly after, the judge came out and said, quote, the law is, and I'm paraphrasing here, likely unconstitutional and stupid. Maybe that's a t-shirt for the Bishop on Air store. Likely unconstitutional and stupid. So, the judge in that case essentially signaling how this was going to go and joining the state from enforcing the law. But we've got a statement here from the National Institute of the Pregnancy Centers. They say that the pro-life ministry's victorious against the state of Illinois' attack. And let me pull this up for you. Illinois Attorney General Kwame Raoul has agreed to order permanently prohibited the state from enforcing the law that declared pro-life speech to be a deceptive business practice and defined as consumer fraud, the sharing of certain information about risks of abortion. Thomas More Society attorneys today filed, together with the Attorney General, a joint motion to enter an agreed order imposing a permanent injunction on the Attorney General. The joint motion was filed in the United States District Court in the Northern District for the signature of Judge Ian Johnson. Again, Johnson had previously said that, here it is, the federal court was spot on in holding that SB 1909 is both stupid and very likely unconstitutional, Peter Breen said. SB 1909 exempts abortion facilities and their speech while exclusively regulating pro-life organizations and their speech in flagrant violation of the First Amendment. So that's an interesting turn of events. That also happening yesterday. So there's been a lot of action on constitutional rights in the state of Illinois where people are trying to challenge state laws, alleging it's a violation of their constitutional rights, and then getting to these types of outcomes. So just some of the other things that we'll continue to track and cover here as you follow along with Bishop on Air. Greatly appreciate you guys tuning in. I got to get the rest of my day going, so be sure to like, subscribe, tell your friends about the live program each and every weekday morning, but also we segment out the clips as well, so that's how some of you ultimately end up seeing these also.